What's your name?
Whitney Mitchell.
All right, Ms. Mitchell, you are before the court on a misdemeanor complaint that alleges two charges. The first charge is that of operating while intoxicated. This is alleged to have occurred on June 30th, 2025. It's a location of Michigan Avenue near Circle K. You understand that charge?
Yes, Your Honor.
There is also with that charge a second offense notice that would make this a misdemeanor punishable by 5 days to 1 year in jail, a $200 to $1,000 fine plus court costs. Court could order community service and any rehabilitative programs the court deems necessary. Could order your vehicle immobilized. Could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. Do you understand the maximum penalties?
Yes, Your Honor.
Count two alleges that on that same date and at that same location that you operated a motor vehicle with the presence of a controlled substance. You understand that?
Yes, Your Honor.
That's a misdemeanor punishable by up to 93 days in jail, a $100 to $500 fine plus court cost. Court could order community service, rehabilitative programs, could order your vehicle immobilized, and could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Yes, Your Honor.
First question I have for you is, do you want to be represented by an attorney? This is the public defender. Yes.
Under Natalie Pate, with and on behalf of Ms. Mitchell, we would waive any formal reading of the complaint. My client stands mute and we would ask for a PR bond and adjourn pretrial date, please, Your Honor.
Defendant every way formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned October 15, 2025, 9 a.m. As to bond in this case, alleged BAC.
Well, Your Honor, there's an alcohol BAC of 0.097. There is also a lab report indicating 16 nanograms per milliliter cocaine, 757 nanograms of the metabolite cocaine, and 67 nanograms of methamphetamine. The defendant's prior is from 2023. It looks like she would have finished probation in late 2024. Based on what I can see, I'm requesting a scram tether and intense supervision at community corrections.
Anything you want to say regarding that?
Your Honor, I would just request a PR bond. I do understand typically in these types of cases, the monitoring at community corrections. So I'd leave that in the court's discretion.
Bond will be set in the amount of $25,000 personal recognizance bond. All other standard conditions, including no assaultive behavior or possession of any weapons. You understand that, ma'am?
Yes.
There is to be no use of any alcohol, recreational marijuana, or any illegal drugs. You understand that?
Yes.
Did you report over to community corrections? Ma'am, if I were to give you a drug test now, right now, are you going to come back clean? Think about it before you answer.
Yes. Well, I have a medical marijuana card.
Her prior was in 2023. Was that a straight? Was that also a combination of drugs?
I am trying to find it here. I can't tell. It may be a city case, which is why I'm not able to locate it.
Got it.
It was just alcohol.
All right. What I'm going to do is I'm going to order the defendant over to community corrections for intensive supervision level, which will have to include drug testing. I do want, at least because of what's located at this point, she's to have drug testing at least 2 times per week until further order of this court. I'm also going to order the defendant is to be placed on a scram monitoring unit or tether. And they will be able to do that over at community corrections. Anything further?
Your Honor.
Nothing further, Your Honor. Thank you.
Thank you.
Court calls case People versus John Neary.
Ashley Phillips to the people.
Your name, sir?
John Neary.
All right. Sir, you are before the court on a misdemeanor complaint that alleges that on or about June 30th, 2025, at the location of 3900 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you did commit the offense of assault and/or assault and battery upon a Hassan Issa. You understand the nature of that charge?
Yes, sir.
All right. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that, sir?
Yes, sir.
All right. First question I have for you. You want to be represented by an attorney?
Yes, sir, I do.
It's a public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Neary, we would waive any further formal reading. My client stands mute and we would ask for an adjourned pretrial date as well as a personal bond, please, Your Honor.
Defendant having waived formal reading standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to October 15th, 2025, 9 a.m. Bond in this case, I'll set his bond at a $5,000 personal recognizance bond below the standard conditions, including no possession of any weapon, no assaultive behavior, or possession of any weapons. You understand that, sir?
When is it? October the 15th?
That's
When
your
is it?
day. But I'm
Well,
asking,
hunting season's coming on. I just want to know how we're going to approach this hunting season thing.
pardon?
Hunting season's coming. I
I
just
knew
want to
you
know
were
how we
going
can
to say
approach this.
that.
Huh?
I knew you were going to
It's
say
just,
that.
I've been doing it since I was like.
You look
8
like a
years old.
hunter. You look like a hunter. And when I said no possession of any weapons, I bet you everything went blank in your head.
That's another thing right there. It's kind of,
Let me
I
ask
mean,
you.
season
this.
actually starts in October.
Hold on.
Boat
Stop.
season.
Stop.
Okay.
Do you bow hunt?
Yes, sir. I both.
You bow and
Yes,
then
sir.
firearm when that opens?
Yes, sir. I also hunt different states as well too. So
Any response regarding the hunting?
I don't have any objection to bow season. At this point, I am going to request no firearms possession or use, Your Honor. I'm trying to get a sense of history.
State basically.
I don't see much that's recent. Any,
Well, bow season opens up on the
the first.
first,
right?
and then firearm is 15 or thereabouts.
it's the
October.
15th here. Yes, sir.
All right. So here's what I'm going to do. I'm going to indicate no possession of any weapons. I will indicate at this time that the defendant may bow hunt. Okay.
Yes, sir.
And then I'll make a determination since your court date is actually the opening day. I'll make a determination about firearms once everybody else is.
Yes, sir. I appreciate it.
Okay. Fair enough.
And it makes sense, Your Honor. I understand a lot of people, that's how they feed themselves. So I get it. Like,
Do what?
thing. People hunt to feed themselves. I get it.
Or just chase Bambi around. I mean, either way.
It's dad. Not baby.
See, I can say all that stuff. I'm not a hunter. I just watch people do it. And I'm amazed at it. But all right. I'm also going to order, sir, no alcohol, recreational marijuana, or any illegal drugs. You understand?
Yes, sir.
that?
Yes, sir. I
All right.
appreciate it.
And then what I'll do is I'll order that you're to have no contact with Hassan Issa. Okay. I think we're all set, and we'll deal with the hunting issue come the 15th.
Thank you.
sir.
Thank you.
Appreciate it.
Court calls case People versus Abigail New.
Do you have the plea form, Your Honor?
I do.
Good day.
Hello, what's your name?
John Michael Punch.
All right, Mr. Funch. The plea form that I have indicates that the defendant will be pleading to an added count to a retail fraud in the third degree, the 93-day offense. On a successful plea, count one would be dismissed. That's the entire understanding of the
That's correct, Your Honor.
May I have him sworn? Is that correct, Ms. Counsel?
Yeah, yes, sir. I'm just actually pulling up the plea form, but I'm sure that's right.
It's okay. Let's have him sworn.
I believe you.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I sure do.
State your name.
John Like a Bunch.
All right, sir, it is this court's understanding you're going to be pleading guilty to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased 3 times the value of the property taken. If that's greater than $500, that would be your maximum fine. You understand that?
Yes, I do.
All right. And understanding all of that, you still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation?
No,
Are you on parole?
not at all.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, not at all.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
I am, Your Honor. Yes.
Yes.
Yes,
And because you believe that you're guilty of this offense?
I am. Yes.
March 5th, 2025, at the location of 3300 Carpenter Road in Pittsfield Township, Washington County, State of Michigan. What did you do at the Home Depot that makes you think that you're guilty?
I had a tire to return and I kind of just returned it myself and there was a $20 difference, the price. And I just walked out with the tire.
You had a tire?
A tire for my wheelbarrow
Oh, okay.
was dumb.
And so,
He purchased a tire at $39.
Right.
It didn't fit, so he brought it back into the store. And rather than waiting and doing the exchange with the customer service, he selected a $59 tire.
is that all correct, sir?
It is, yes.
So, and then when you selected the new tire, you did that and you walked out without paying the
I did,
difference?
yes.
And you knew that's what you were doing at the time?
Yes, absolutely.
All right. You didn't have anybody's permission at Home Depot to do that, did you?
No, not at all.
And the item that you took out that was priced at the $59, that was an item that they had offered for sale?
They did, yes.
All right. Counsel, have I complied with the court rule? Well, sir, I do have to advise you that if between the time of the acceptance of this plea and your time of sentencing, that if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea. You understand that, sir?
Yes, won't happen again. Yes, I do.
And also, sir, any recommendation or evaluation by the court would no longer be entitled.
Yes,
The court would no longer be bound by you, understand? Okay. Is counsel aware of any other promises, threats, or other inducements which had led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 2, count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
October 22nd at 12 noon.
October 22nd, 2025, 12 noon. Sir, looks like you have some other issues here.
no?
Well, I'm not,
Oh, sure.
Mr. Allen.
You don't have no warrants.
No, I don't. No. Yeah,
Right, I've got two warrants, and I've got a warrant, which this is an old case because it has a 97 case number on it. And it was transferred from our original case management system into the new one. I'm not sure why it appears the way that it does, but it's a civil case, but for whatever odd reason has a 5,000 10% bond on the case. And they issued the bench warrant. It was a Samuel Hall Jr. versus John Prince. I don't know why that, when I'm looking at the case, there may have been, oh, I know why. All right. There was a subpoena, and I'm having to piece it together, but there was a subpoena that was issued. You didn't appear to court. Ultimately, at least my procedure was there was a show cause and then a bench warrant because you didn't appear.
Does it show he was served though, the subpoena?
I'm not.
I didn't know that.
There was a point at which there was no service. I do see that on here, but then they filed a new subpoena. Discovery was filed, and at a later date, then the bench warrant was issued. So I have to assume that the bench warrant was issued. That was, although it's a 97 case, because I took over that docket, I'm listed actually as the judge of record in that case. But I would not be the one that would be handling it now. What I'm going to do in that case, because it's so old, on that one, I'm going to cancel the bench warrant. All right. And then I'll just indicate that they need to reset before Judge Barr, who's handling our civil docket. You have another civil case that's from 2020. And the plaintiff, and it's a civil matter, is a Susan Riesel. I don't know if you know that person versus you. In that case, again, it appears the same thing, except in 2023, a debtor's exam was scheduled before Judge Barr. And on April 18th of 2023, you failed to appear for that debtor's exam. The judge issued a warrant.
Was notice returned or?
I have no idea. I'm just looking at the file or at the printout. I would suspect that if notice were returned and Judge Barr knew about that, he would not have issued a warrant. But a bench warrant was issued on that. A bench warrant, for whatever odd reason, even though it was in April, was then issued October 10th of 2023, and it's gone through this year in February. The warrant was valid.
We have case numbers because we don't have access.
I canceled the one,
Okay.
one case number, the one that there's a valid, let me just give it. One case number is 97-2C3143. That's the one that I canceled the warrant on. The other one is 2004 C0243. both of them, it appears, come from small claims matters.
Your Honor, is
Um,
there an address in the 243? I'm trying to make sure you got notice of all this.
in the 243, there's the address of Parker Road, but I don't know when the warrant and everything came through whether or not that was, no, I'm sorry, it's not Parker Road. It's Outer Drive. It's the same address that I have on this case.
So I'm asking the court to not take him into custody, but
It's a valid warrant. You're gonna address that before Judge Barr. That's his warrant that was issued on the civil case. It's a cash bond only warrant from his failure to appear for a debtor's exam.
But, Your Honor, I'll be brief. As the court knows, we don't have access to JIS. Usually we'll run our clients' names through JIS and have the benefit of at least alerting our clients to warrants.
Right.
Without access to JIS, and I interviewed him in the court, I interviewed him in the interview room, he wasn't aware of any warrants. That's why I was asking about the addresses and whether he had properly been served the subpoenas or served with notice of those debtor hearings. And so because I don't have JIS, I can't help him.
I will straighten it out.
Well, I understand. And Mr. Brown, I appreciate what you're saying. I think it's what has transpired is just crazy regarding JIS. I don't agree with any of it at all. I think certainly to those that have asked, I've expressed that. This is the one danger that happens. People get locked up because you guys who do a fantastic job don't have the benefit of being able to get open access to the information that's contained in the case management file. It's an abomination. I do consider it. If you raise the issue, it may be a violation. I'd have to look at it as an individual's due process and constitutional rights, because I have to do what I have to do here. But the court itself, quite frankly, is impeding your ability to do that. Something's wrong. There's going to have to be a ruling on it if it's raised. So you are more than free to raise that before me, since I'm the one sending, or raise it before Judge Barr because this is his case. But at this time, I do have a valid warrant. I'm going to take him into custody, sir, so that you know the bond amount that I have here is $2,650 cash.
How much? 2,000?
$2,650.
You got that on?
No.
That sounds like on the civil case, that may have been the judgment amount. And then when you didn't appear for the debtor's exam, that became the bench warrant.
What can I say? How do we get a hold of them?
Hold of who?
The people I owe the money to.
Well, hold on.
Well,
You got to go with the court officer. And if you got a credit card or somebody you can holler at, you can call for the 265. Maybe you can post it.
not 265, 2,000.
Oh, 2,065. No 10% privilege?
It's a cash bond that normally would come off a civil case.
So you got to go with the court officer. Make
All
some
right.
calls.
Go with the court officer. Mr. Brown, if for whatever reason he's not released or there's some difficulty, you can't get before Judge Barr to adjust or do something, I will entertain whatever motion you have, because I realize this would not have happened but for what has transpired over the past few weeks.
Thank you, Your Honor.
You're welcome.
Judge Simpson presides over a series of courtroom hearings involving very different defendants and charges, revealing how every case demands a unique balance of justice and discretion. The first defendant faces serious second offense DUI charges after prosecutors present evidence of alcohol, cocaine, and methamphetamine in her system, leading the judge to impose strict bond conditions, frequent drug testing, and continuous scram monitoring. Another defendant, charged with misdemeanor assault, surprises the courtroom by asking whether he can still hunt during the upcoming season, prompting a light-hearted exchange before the judge allows bow hunting but reserves judgment on firearm use. The session then shifts to a retail fraud case where a man openly admits walking out of Home Depot with a more expensive replacement tire without paying the price difference, resulting in a guilty plea and a future sentencing date. Finally, what appears to be a routine hearing takes an unexpected turn when the judge discovers long-forgotten civil bench warrants tied to missed court appearances. Frustrated by administrative failures and limited access to court records, the judge criticizes the system for creating unnecessary legal complications while ultimately enforcing the outstanding warrant, highlighting the difficult balance between fairness, accountability, and the rule of law in today's courtroom.